Welcome everyone back to the Law Academy and specifically to the Law of Tort. This lesson is going to introduce topic number 7 of our studies in the Law of Tort, focusing specifically on the idea of occupiers' liability. Now, we're going to take an introduction, as I've mentioned, to the topic of occupiers' liability in this lesson, discuss some of the ways in which occupiers' liability has been construed in the past, so namely talking about the common law principles of occupiers' liability prior to the legislation, as well as taking a brief outline to the legislation itself, specifically the two Occupiers' Liability Acts that deal with two distinctively specific areas of occupiers' liability. The previous lesson finished our discussion on the subject and the issue of vicarious liability. We noted that vicarious liability is something of a general offshoot to the concept of employer's liability in the law of tort, but of course referred mainly to the ways in which an employer may be liable for the tortious activity of their employees towards some kind of third party. Occupiers' liability is the next major tort we're going to be spending our time examining. Now, just like with negligence, in fact, occupiers' liability is one of the major torts that we can think of in this series of lessons. We can really generally delineate torts into the really popular, the really common torts, and the ones that are almost always discussed and examined in any course at university. So, for example, negligence, of course, nuisance would fall into that category. So too would occupiers' liability. And then there are the other torts that are less prevalent, which may or may not form part of an ordinary law of tort course. So product liability, vicarious liability, defamation to an extent as well. This lesson is, of course, the next few lessons is, of course, talking about occupiers' liability. So really, the first place that we should begin is by asking the question. What is the question? What is occupiers' liability? What do we mean when we talk about occupiers' liability? What are we referring to? Well, simply put, occupiers' liability can be construed as, or it can be viewed and understood as, the duty of care which ought to be owed by those who have some kind of control of property and or land to those who may enter that property and or land. So if you have some kind of control over some land and somebody enters onto that property for whatever reason, then there ought to be at least, at the very least, certain principles of duty of care that is owed to those individuals. It's really that simple. And it is a tort which essentially arises out of the tort of negligence. It is a type of tort that is seen to be something of an offshoot to the tort of negligence. But of course it is only applicable in very specific circumstances, this being of course a duty of care to an occupier. And so as a result of which it is a type of negligence, if you will, but it is a negligence that is construed towards a very specific set of circumstances, the circumstances where somebody enters onto property or land that you control. Now, since we're only talking about this from an introductory perspective in this video, let's just talk about how the law on this area develops, because the history of this topic is quite interesting in and of itself. When it comes to the topic of occupiers' liability itself is actually one of those quite rare areas of the law where there is actually a shift towards statutory regulation, and there is a shift away from the basic principles of the common law. This is quite rare, as I've mentioned, in the law of tort, because tort is often construed as a common law area, really. It's quite heavy in terms of common law development. So negligence is almost entirely made up of case law and developed out of case law. So too is various other areas of legislation, areas of law, sorry. And so it's quite rare that there is specifically statutory regulation of tortious activity. But occupiers' liability is one such example where this takes place. There are two pieces of legislation which one ought to be aware of, and these are the two pieces of legislation which we, as law students and as students of occupiers liability, are going to spend the most of our time studying. The first one is the 1957 Occupiers Liability Act. This is arguably the most important of the two, and is the one that we are going to be spending the vast majority of our time studying and exploring. The second is an updated version of the Occupier, or at least an update to the Occupiers Liability Act, which is the 1984 Act, which does essentially different things and covers very specific circumstances of occupiers' liability. A little bit less important than the former act. We will still spend some time examining it, and we'll spend a couple of lessons on it, but for the most part we're going to be spending the majority of our time looking at the 1957 legislation, the key principles therein, but rather than spending much time on the 1984 legislation. So, before I finish this introductory lesson, I want to just briefly talk about the common law principles that existed prior to the 1957 Occupiers Liability Act. Because as I mentioned, what happened really was a codification of the common law principles into statute, and there was the adoption of some of the basic common law principles from the statute into from the common law, should I say, into the statute. So what were some of these common law principles that had existed prior to the instigation of legislation? Well, the old law on occupiers' liability would essentially give certain rights over those who enter onto the property in which you occupy, or own, or otherwise control. Now, really, the strength of these rights would depend on the type of relationship and also the purpose for your being on the property. So there would be almost something of a hierarchy of rights which existed given the relationship that you had to the occupier, as well as the purpose for your visit to the property. So, for example, if you were on the property for a reason which arose out of the performance of a contract, then there would be quite strong rights. And quite strong duty of care principles that would be enshrined onto you as part of that performance of the contract. If you were invited onto the property as well, this would also be a category of rights which can exist, whereby you have, as an individual who occupies the property, a duty of care towards those who are invited onto your property, to essentially not cause negligence onto them. Licensees, again, is also an area of relationship and purpose of being on the property that is a little bit less strong than that of the others, and is of course not a proprietary right, which we always know, we all know at least from our studies in land law. And then you also have this idea of trespassers. Now, you might think that, at least with a basic common understanding, that, well, trespassers surely don't have any rights over or there is no duty of care to a trespasser for keeping them safe, or at least keeping them out of the sense of negligence. But this isn't actually true. There are rights to trespassers, at least in the new law on the matter. When it comes to the old law, the common law principles, the latter, the idea of trespassers, would garner you very little in terms of rights, but you actually do have some rights as a trespasser onto the property of another individual in occupiers' liability. This is discussed more in relation to the Occupiers Liability Act from 1984 rather than from the 57 legislation, and we'll get to that, of course, as time goes on in future lessons. In this lesson, what we're going to be doing is talking about the concept of occupiers' liability in more detail than we had discussed previously. So, as mentioned in the previous lesson, essentially what we did was take an introduction to the nature of occupiers' liability, what occupiers' liability is, and then just outline the ways in which occupiers' liability is regulated. It's regulated, of course, through legislation. And then, of course, on top of that, you have the interpretation of legislation through the common law, etc., etc. This lesson is going to start unpacking this law in more detail, talking about the Occupiers Liability Act of 1957, examining the scope of occupiers liability and to whom a duty is owed. And then what we will do is in the next lesson talk about the duty of care in relation to occupiers' liability. We will talk about the standard of care, and then we will talk about some subsidiary factors, such as the duty to a trespasser, the way in which the idea of occupiers' liability relates to children, and then fundamentally come to some conclusions therein. So let's begin then with the first part of the 1957 Occupiers' Liability Act, Section 1, Subsection 1. It says here that, quote, the rules enacted by the two next following sections shall have effect in place of the rules of the common law. So if you remember back, the previous lesson talked a little bit about the ways in which the Occupiers' Liability Acts codified in statute the previously existing rules in the common law. So they shall have effect in place of the rules of the common law to regulate the duty which an occupier of premises owes to his visitors in respects to dangers due to the state of the premises or to things done or omitted to be done on them. That's what occupiers' liability is. That's how we defined it in the previous lesson. That's how the legislation thinks about it here. So this first provision outlines essentially the scope of the legislation. The courts have interpreted this piece of legislation as suggestive of the actions that are done mainly in relation to the land itself, rather than necessarily some performance that is done on the land itself. So it is a something that is done in relation to the land itself, and we shall see how this actually operates when we look at occupiers' liability cases and how occupiers' liability has been discussed and dealt with the case law and the kinds of factual circumstances by which occupiers' liability relates. Subsection 2 says the following. Quote, the rules so enacted shall regulate the nature of the duty imposed in law in consequence of a person's occupation or control of premises, and of any invitation or premises he gives to another to enter or use the premises, but they shall not alter the rules of the common law as to the persons on whom a duty is so imposed or to whom it is owed. And accordingly, for the purpose of the rules so enacted, the persons who are to be treated as an occupier and as his visitors are the same as the persons who would at common law be treated as an occupier and as his invitees or licensees. So again, this is just essentially talking about the regulation of the duty imposed in terms of the ways in which, the scope in which it is applied. Essentially, we're talking about a duty that is given to a person who controls a premises, who gives an invitation or permission to an individual to enter and use the premises, and therefore, as a result of which, suggests that there is a duty of care that is owed there in relation to the land, which is of course what we define as occupiers' liability and had defined in the previous lesson. Let's get to some case law then. Let's talk firstly about the case of Wheaton Laken from 1966. This case was a case involving the defendants who had been the owners of a pub, at which point some third party P was a licensee who had been under contract for the management of the pub. So you have almost a little bit of a hierarchy going off here, where you have the defendants who owned the pub, you have some third party who had been a licensee and essentially had been a manager of the pub under contract. The claimants in this case were a husband and wife who had been lodgers at the pub. And owing to the conditions of one of the staircases, essentially they didn't have proper handrails and inadequate lighting, the claimant's husband, the husband in this relationship, had fallen down the stairs and unfortunately died as a result of this accident. The question for the courts was whether or not liability can be handed to C owing to her husband's death as occupiers in the pub. So where can liability rise, essentially? And the court held that there was a duty of care by both the owner of the property and the property manager. So not only did the owners, the defendants, have a duty of care in relation to occupiers' liability, but so too did this third party who had been the managers of the pub. So there was two people who had relationship, an occupiers' liability in relation to this, or had a duty of care in relation to this. But the courts also then went on to suggest that the duty, in fact, had not been breached. They had not breached their duty, as the removing of a light bulb that had essentially reduced the lighting in the staircase, which then obviously led to the death of the individual, had not been done by them, but had been done by some stranger third party, another third party who had removed the light bulb. And so as a result of which, you see here that it was not them that had the duty of, well, they had a duty of care, sorry, but it wasn't them who had breached that duty by removing the light bulb and creating the conditions that were so dangerous that led to the death of the individual. This case illustrates, firstly, that multiple people can have a duty of care under occupiers' liability as owners, because it wasn't just the owner of the pub that had a duty of care under occupiers' liability, but it was also somebody who had license to manage the pub, which was, of course, the building manager as well. And so this therefore illustrates the fact that multiple people who control property, who control or have some kind of ownership over a piece of land, can therefore have a duty of care in relation to occupiers' liability in relation to that land. Welcome back, everybody, to our studies in the law of tort. This lesson is going to talk about the concept of occupiers' liability in relation to the duty of care. We noted in the previous lesson that a duty of care can be owed by more than just one single individual when it comes to occupiers' liability. We noted the case of Wheaton Laken, the case in which we have a building manager who is a licensee who has license to essentially operate and manage a pub. And then we also obviously have the owner of said pub. And it was held here that a duty of care, even though there was not a breach of a duty of care in that particular case, owing to a third party involvement in the creating of dangerous conditions, we still noted that a duty of care was owed by both people. This lesson is going to focus a little bit more on this idea of the duty of care, taking specific attention to what the duty of care is and to whom a duty of care is owed. And I'm going to refer us back to section 1, subsection 2, because it is that part of the legislation that outlines who are owed a duty of care and those who are considered to be visitors under that legislation. Visitors are described as those who have either got express permission or implied permission to be on the property. And so this will include, for example, those who you are inviting onto a property, who are licensees, those who you invite to have permission to work on your property, those who go onto the property to deliver, let's say, letters, so postmen, for example, who will have an implied permission to be on that property. Let's illustrate this case a little bit more succinctly. And we're going to talk about the case from 1911 of Larry and Walker. This was a case in which we have a claimant who was using a field to essentially cross as a shortcut. They crossed a field that was owned by the defendant. Like I said, it was a shortcut, and in fact it was a commonly used shortcut as a way to get to a local railway station. So it wasn't just the claimant who had been using this crossing in the field in order to reach the other side to get to a local railway station, but it was a commonly used shortcut that was used by many other individuals as well. Now, in addition to it being a commonly used shortcut that the claimant would have occasionally utilised, it was also something that the defendant knew was a commonly used shortcut. And even though they knew it was a commonly used shortcut, they did not take necessary appropriate steps to ensure that people coming onto that land would not be injured in the process. In fact, they had essentially allowed and put a horse on the land to graze in the field, knowing that it could potentially cause some issue. There was a foreseeable chance that there could have been some issue caused as a result of having a horse on that part of the land that people would be commonly walking through. When the claimant was therefore injured as a result of the horse being on this land, it was argued that no duty was owed, owing to the fact that they were a trespasser and had rights to be on and had no rights essentially to be on the premises. However, it was held by the courts that, despite the fact that there was no explicit permission that had been granted on the part of the defendant to the claimant, it was still argued that there was an implied license owing to a number of factors, owing to the nature of the property as a field, and specifically owing to the popularity of the field as a shortcut. Given the fact that the defendant knew that this was a popular shortcut. They didn't take any steps to ensure that people would not use it as a popular shortcut. They didn't put signs or fences or locked gates up. They just knew that it was a popular shortcut and that people would walk through it. There was this implied permission that was granted, owing to this idea of the defendant knowing of its popularity and knowing that people walked across it and didn't do anything to stop them from doing so. And so, owing to these two factors, there was an implied license. And what this case really illustrates is the fact that you don't need to be explicit in terms of giving a person license to go on and enter your property in order for a license to exist, or in order for a duty of care to exist by way of occupiers liability, or more succinctly, in order to ensure that a trespasser hasn't entered onto your property, or that people who go onto the property aren't considered trespassers. You don't need explicit license for that to take place. In fact, there can be an implied permission granted. A further case which illustrates these points is a case from 1987, the case of Ferguson and Welsh. What this case illustrates is the limitations on the duty that is owed. So far we've talked about a case in which you don't necessarily have to be explicit in granting a duty of care. Well, this case illustrates the limitations on this rule. The defendants was a district council, in this case. They were a district council who had hired a contractor to do work. The council made it very clear that subcontracting would not be permitted unless they approved the contractor and hired someone else to do the work anyway as a subcontractor. The work was a demolition job. Now, one of the employees of the subcontractor were the claimants, and they had been injured as the result of the unsafe demolition. The employee of the subcontractor then sued the defendants, the district council, under the basic rules of occupiers liability. And it was held that while the district council did not have liability owing to the nature of a standard of care, the subcontractors were considered visitors for the purposes of occupiers liability. This is because the contractors, despite expressly being told not to do so, had what is known as ostensible authority to hire the subcontractors. So even in circumstances in which you have an explicit request or an explicit command or demand that says you should not hire subcontractors, it was held by the courts that there was an ostensible authority in doing so, which meant that there was still a duty of care owed, that they were not considered to be trespassers owing to the nature of the work. Again, just like in the case of Wheat and Laken, the courts held that this relationship existed, that this duty of care existed, that this occupiers liability relationship existed between the subcontractor's employee and also the district council. But then they held that fundamentally, even though this all existed, there was still not this the existence of this standard, that or at least they had not gone beyond the standard of care, fallen below the standard of care in establishing an occupiers liability case. So even though they failed when it came to the final merits of the case, they failed on that account that there was not occupiers liability here, or that they were not liable in occupiers liability, they still nevertheless held that there was a duty of care owed, and so as a result of which represents quite interesting case law on the matter. In this very short lesson, what we're going to do is spend some time talking about occupiers liability and the relationship to the standard of care. So we noted at the end of the previous lesson that in the circumstance where we have the district council that explicitly says no contractors, or subcontractors, should I say, should be allowed for this demolition job, the courts held that there was still a duty of care that was owing to this idea of ostensible authority. But we also concluded that case by saying that the courts fundamentally rejected the view that they had fallen below the standard of care. And so that really begs the question, what is the standard of care? How does the law apply the standard of care? And is there any case law that we can look at to illustrate the point of a standard of care? So this lesson, like I said at the start, isn't particularly very long. We're just going to cover it quite briefly. It's essentially going to be covering elements and questions and ideas that we have looked at previously already. The idea of a standard of care is relatively well-established law, whether or not we're talking about negligence or whether or not we're talking about occupiers' liability. The standard of care is relatively stable in terms of what is required. And I'm going to draw your attention first to Section 2, Subsection 2 of the 1957 Occupiers' Liability Act, because they say in this piece of legislation, quote, the common duty of care is a duty to take such care as in all circumstances of the case, and that this is reasonable to see that the visitor will be reasonably safe in using the premises for the purposes, shall I say, for which he is invited or permitted by the occupier to be there. So, the common duty of care is a duty to take such care in all circumstances of a case, which is reasonable to see that the visitor will be reasonably safe. So the point here, and the point here that relates to the standard, is specifically that we have a duty to ensure that a reasonable person is reasonably safe. So it is reasonably the case that the visitor is reasonably safe in using the premises for the purposes for which they are invited or permitted by the occupier to be there. So fundamentally, therefore, the question is, who is reasonably safe? And this is the standard that is required to be spoken about. According to this provision, it is the visitor who ought to be reasonably safe in the property that is being questioned. And so a visitor who comes onto the premises either by permission or through an invite, whether that be expressly stated or whether that be implied, through the nature of the relationship or the nature of the property or the nature of the defendants or the owners, should I say, the occupiers' knowledge of people entering onto the land. And they ought to be reasonably safe in that conclusion. They ought to be reasonably safe, and that if they fall below this standard, then we can make a claim that they may be a claim, a potentially valid claim in occupiers' liability. So what this means is that the premises aren't considered to be reasonably safe for the purposes of this standard. And in addition, it is also referencing this idea of a common duty of care. And this refers to the duty which is applied for the purposes for which the visitor was allowed entry. And so fundamentally, that's it when we talk about the standard of care. There are other issues that we can think about, but fundamentally it is something of a transformation of what we have already spoken about in previous lessons relating to the standard of care, specifically in relation to the standard of care applied to negligence cases and other such examples of that kind of nature. So for the most part, the duty of care in this relationship, or the standard of care, should I say, isn't particularly controversial. The legislation says as follows, that you should be reasonably safe, and this idea of reasonable safety is the standard that is applied when we think about occupiers' liability. Welcome back, everybody, to our studies in the law of tort. This lesson is going to talk about occupiers' liability, continuing our discussion of this topic, and focus on something that is of particular importance, which has been highlighted at various different stages in textbooks and, of course, in the legislation. This is the relationship with occupiers' liability and its application to that of children. We'll talk about the specific highlighted elements within the statute in this lesson. We shall also talk about some case law that illustrates some of the points and looks at essentially what the courts have done in being able to deal with some of these problems. So we're exploring some of the basic elements of occupiers' liability, specifically the consideration that ought to be had when we relate the principles of law to that of children. And the Occupiers Liability Act deals with this problem specifically, or deals with this consideration specifically. In Section 2, subsection 3a, we get the fact here that the circumstances relevant for the present purpose include the degree of care and want of care, which would ordinarily be looked for in such a visitor, so that in proper cases, an occupier must be prepared for children to be less than careful than adults. And essentially, the legislation goes on to speak about some of the other questions and issues that relate to other elements, but in specific, to the idea of children, an occupier must be prepared for children to be less careful than adults. What does this mean? Well, fundamentally, what this tells us is that there may potentially be a higher standard that is applied to that of occupiers liability, where the people who are coming onto the property are in fact children. And let's think about some cases that illustrate this point in more detail. The 1922 case of Glasgow Corporation versus Taylor was a case in which we have a young child who was playing in a public park. He then went over and ate some of the berries that were on one of the bushes in the park, which turned out to be poisonous. Now, if we were to apply the normal standards for non-children, for adults, in the case of occupiers liability, it would in fact be the case that the claimant was a trespasser for the purposes of the picking of the berries. They didn't have expressed or implied permission to pick those berries, nor did they nor was there any recourse for inviting them to do so in the first place. And so as a result of which, you would suggest that for adults, this would be a situation of trespass. And so you wouldn't even need to deal with the 57 legislation, or prior to this would have been the common law principles. And so, if you remember back to the very first lessons on occupiers liability, looking at the old law, there would be very little duty of care owed to an individual who was a trespasser for the purposes of picking the berries. So there would be very little of a duty. However, owing to the fact that we're talking about a child eating these berries, and relying on a principle known as allurement, the child was treated as a licensee, and as a result of which a duty of care in fact was owed. So the important point to remember here is that in subsection 2.3a, we have to take into consideration, and an occupier must be prepared when looking at these circumstances, that children will be less careful than that of adults. So a higher standard is owed to that of children who enter onto your property, owing to the fact that they are going to be less careful, they're going to be more reckless, they're not going to understand the dangers of particular things. And this case perfectly illustrates that point. Most adults won't be so reckless as to just pick random berries off a bush and eat them. Children, however, are not going to know the difference between poisonous berries and non-poisonous berries, and so as a result of which, a child picking a berry off a bush is not going to be seen as something of a similar standard of recklessness as ordinary adults. And so we can rely on this principle, and we can rely on this principle known as allurement, to suggest that a child shouldn't be treated as a trespasser, and therefore no duty of care is owed to the people who owned the public park, the district council, the council in question, the local council, should I say. But instead, because they were a child, and because they were more reckless than that of an adult, and because of the principle of allurement, it should be noted that they should be treated not as a trespasser and therefore no duty of care, but as a licensee, and as such, a duty of care would be owed to the local council in ensuring that that child shouldn't have essentially been able to eat the bushes that were poisonous. Another illustration of this comes just before the introduction of the Occupiers Liability Act in 1955. This case of Phipps versus Rochester Corporation is a case which also involved a young boy, and it also involved a situation where this young boy was picking berries with his sister. The boy was aged 5, so we're talking about a very, very young child here. We're not talking about a child who is 15 or 16 and who may and should know better. We're talking about someone who is 5. This was on an estate which was developed by the defendant. So the defendant would have had a liability under occupiers liability and represent an occupier. Rather than the berries causing harm or damage to the child, in fact the boy would fall into an open trench, which would of course cause some injury to that child. What is quite interesting, however, is that they were held, the defendants, the people who were developed the estate, the occupiers, were held to not be liable in occupiers' liability for this particular incident. The reasoning for this was given the fact that children who are very young would reasonably be expected to have been supervised by their parents or someone with de facto parental responsibility. The occupier should and would have had this expectation as well. And so as a result of which, there can be an assumption on the part of the occupier, in this case being the person who developed the estate, that the responsibility for those children lied in that of the parents. And so that it should have been the parents that are at fault for the lack of care, essentially, to their child. So in concluding this point, essentially, what we're trying to say here, and what this case illustrates, is the view that children who are very, very young are going to be reasonably expected to have been supervised by somebody who is an adult. And when we think about a child who is aged 5, this is obviously a very reasonable expectation. So essentially, the people who develop the estate, the occupiers, shouldn't have the expectation and shouldn't be held to a standard of safety that would be one that essentially accounts for children who are unsupervised under the age of 5. They should reasonably be expected to uphold a standard of safety that is of children who are age 5 who are being supervised by their parents. This would make sense, but not just children who are age 5 who are not being supervised at all. And you can understand why this case illustrates this point, and you can understand why this point is essentially enshrined in the case law. Because if we take some theoretical and hypothetical thought experiments, pretty much any place would be a dangerous place for a child aged 5 to walk around on their own. And so we wouldn't expect every single occupier of all and any kind of property to have reasonably considered children wandering around on their own, age 5, and therefore be liable for any injury that is caused owing to the nature of the property, because children ought to be supervised by their parents at such a young age. So we can understand why this particular principle makes sense, or at least I hope you can understand why this principle makes sense. Fundamentally, that is the point of this case, and it gives us an extra bit of nuance in relation to the process by which we can determine the extent to which a duty of care is owed when it comes to children who are on the property in question. In this final lesson looking at occupiers' liability, I want to spend a little bit of time talking about the duty that is owed to trespassers. Now, this is something that has seen something of a change in the law, at least from the old common law perspectives on occupiers' liability, going through to the 1957 Act, and then going through to the later Act from the 1980s. So we'll spend some time in this lesson looking at the legislation that we have spent very little time examining in this series because, of course, it relates specifically to that of duties to a trespasser. This is, of course, the Occupiers' Liability Act of 1984. And really, when we think about the duty to trespassers, this is something that's only had to develop over time. So the old law, as I mentioned previously, gave very little by way of a duty in occupiers' liability to those who are trespassers on property. Equally so as well, the 1957 legislation also doesn't really deal with trespassers that much either. It is only until we get to 1984 that we start to see a certain amount of duty of care that can be owed to that of a trespasser. In terms of the development in the common law, we see the case from 1972 of Harrington versus the British Rail Board expand the scope of a duty to trespassers beyond that of the old law, which was only owed to a duty in circumstances of the deliberate and/or reckless causing of harm. So this was actually not really necessarily a duty to trespassers per se specifically, but just a common duty to humanity. So fundamentally, the old law relating to the duty of trespassers was that of just don't deliberately or recklessly cause harm onto a trespasser, and that's just the duty of common humanity. That was all that existed. There wasn't a special set of provisions. There wasn't a special law or relationship relating to a duty to a trespasser, and the 57 Act didn't expand on this either. It is the common law that expands on this all the way up until 1984 when we get the legislation. This new Occupiers Liability Act was passed, like I said, in 1984, and it gives us new legislation and new provisions on the relationship between occupiers' liability and that of trespassers. So it would expand the scope of occupiers' liability to that of, quote, persons other than visitors. So this includes trespassers, of course, because trespassers aren't visitors onto the property. And it implies an expansion beyond that of a visitor to a property, as per the original legislation, to that of people who may be also trespassers. And it includes liability for those who are using the premises as a private right-of-way. So the Occupiers Liability Act of 1984 doesn't just refer to trespassers, although that's what is one of its main important elements. But it just expands the law, should I say, to anybody who is not a visitor, persons other than visitors. So it includes trespassers, but it is not limited to that of trespassers, because people who use premises as a private right of way are not considered to be visitors, but are also not necessarily considered to be trespassers either. Specifically, though, let's think about this in relation to trespassers, because that's what the video lesson is essentially telling us to do, or the video lesson, the title of the video lesson. And we're going to look firstly at Occupiers Liability Act, Section 1, Subsection 3, where it says, quote, an occupier of premises owes a duty to another, bracket, not being a visitor, in respect of any such risk as is referred to in subsection 1 above, if he is aware of the danger or has reasonable grounds to believe that it exists, he knows or has reasonable grounds to believe that the other is in the vicinity of the danger concerned, or that he may come into the vicinity of the danger, and the risk is one against which, in all the circumstances of the case, he may reasonably be expected to offer the other person some protection. So what this is essentially telling us is, if this person isn't a visitor, and they are a trespasser, they could be a trespasser, then so long as you are aware of the danger or have a reasonable belief in the existence of the danger, as well as having a reasonable belief that the person in question who is not a visitor is in the vicinity of the danger, or may come into the vicinity of the danger, and the risk is one which may reasonably be expected to allow the person some protection, then even if that person, not being a visitor, is a trespasser, you can't just allow that person to get injured or potentially killed as a result of the danger that you know of exists. But it requires three elements. It requires, firstly, a reasonable belief in the existence of the danger, or just an awareness of the danger therein. A reasonable belief or an awareness that the individual is either in the vicinity of the danger or may come into the vicinity of the danger. And then finally, a reasonable expectation that you should offer this person some protection from the danger that you know exists on the one hand, and that you know or have reason to believe the person who is not a visitor is either in the vicinity of or may come into the vicinity of. Those are the circumstances by which we can understand this particular legislation. Let's illustrate this then with a case from 2003, the case of Tomlinson versus Congleton, DC. Again, another word that I find difficult to pronounce. This was a case in which a claimant was 18 and had driven into a lake and injured himself. The lake was owned by the defendant, and he had put up signs saying dangerous water, no swimming. It was very clear that the claimant had failed to recognise and take into account the sign that had been there, dangerous water, no swimming. In addition to this, it was made clear that the danger of the water was such that more would be needed to be done by the defendant in order to ensure that there was an adequate amount of protection against this danger. However, at the time of the accident, at the time at which the claimant had driven into the lake, this had not happened. This had not been the case. It was held, however, by the House of Lords that while the provision of Section 1, subsection 3b had been satisfied, the claim failed on the basis of the other two provisions. So this was obviously in relation. We have here that the defendant had reasonable grounds to believe that another person could be in the vicinity of the danger, or may have entered into the vicinity, or may come to enter into the vicinity of the danger. He failed in the circumstances in which, firstly, there was an awareness of the danger or a reasonable belief in the danger that it existed. But then, more importantly, the third point, that he may reasonably be expected to offer some form of protection to this individual. And so, essentially, the dangerous water, no swimming, was enough to essentially avoid liability by way of occupiers liability in relation to that, even though there was a clear recognition that the sign was not adequate necessarily to be able to prevent this kind of injury, to prevent this kind of damage caused onto the claimant.